Hello. I want to talk about a few things that aren't entirely related other than they've been talked about in the last few days. The first thing is it is interesting. I have filmed 2 videos in San Francisco that got seemingly opposite reactions. I filmed the gay pride parade in San Francisco. Ergo, I was gay. Then I filmed a Black Lives Matter / anti-detention center video, and some people thought that made me anti-immigrant, and other people thought that as soon as I shut the camera off, I, in quotes, slunk over and joined the protest. Neither of which are true, by the way. Although, I have to admit, watching the gay pride parade did make me gay. I am now certified 100% gay. So for those of you who spam that incessantly, thinking that that's somehow, I don't know, shaming me or whatever, I made the joke originally, dude. You're dumb. You're dumb. Dumb. Anyway. So that's the first thing. Second thing is news. So I drew a distinction between commercial and non-commercial, and then news. News may be commercial or non-commercial. Generally speaking, news is presented via commercial outlets. The New York Times is a for-profit corporation. They gather and prepare and disseminate the news for the purpose of making a profit. Your mom and your aunt gossiping over the kitchen table are disseminating news for personal reasons, not for profit. The distinction that I was hoping to draw, and that apparently many of you can't quite grasp, is that what he's doing is commercial. And it's not news. There is an exception in the Beverly Hills Municipal Code for news. Now, that exception has been the California Film Commission works with these cities to determine, the cities draft their ordinances following the guidelines of the California Film Commission, and then the California Film Commission, I believe, has to review it or something. I'm not entirely sure of that process, but they're involved in it. But that means that most of these provisions are going to be looked at along the same lines, and they're going to encompass the same things. And if you look at the California Parks, the Code of California, or the California Regulations Code for photography in California state parks, they lump in filming for the internet with filming for commercials, television, and for movies. And if you look at the city of San Francisco's ordinances, they modify the news to breaking news. They add breaking in front of it. And that makes sense. There is no reason to have a film crew go to City Hall to film B-roll footage. There's no breaking news. There's no news purpose for it. Will it eventually be used in a news story? Sure. It'll probably be used in a lot of news stories. But the City Hall doesn't have to give the news crew unfettered access to do that, because it's not breaking news. So my distinction again is that what SGV News was doing, or SVG, I don't really know, and I don't really care. I know lots of people tried to correct me in the comments, but I don't care enough to figure out the difference or remember the difference, because he's a retard and he says and does retarded things. But what he was doing there was not covering the news. Now, he may cover the news on his channel from time to time, and that's great. And while he's covering the news, he probably is exempt from their requirements that he get a permit while he's actually filming the news. And it's not his interpretation or this community's warped interpretation of what news is. News is going to be what your ordinary reasonable citizen would consider news. And most ordinary reasonable citizens don't consider going to City Hall and causing a disturbance to be breaking news, to be newsworthy. Now, you get a lot of people in comments on those things saying that, well, the photographers didn't cause the disturbance. There was no disturbance until the police showed up. The police caused the disturbance. Well, here's your sign, kids. The police don't just magically appear whenever auditors show up. The police are called there, sometimes by the auditors, more often than perhaps this community believes, by the auditors. The police don't cause the disturbance when they show up. The police are responding to calls of disturbances. A concerned citizen is the precipitating factor behind the police arriving 9 times out of 10. And finally, words matter. And I had Eric the Fathead and somebody else both challenge me on the you can't sustain an action for a Bane Act violation on an unlawful arrest. And like, well, yes, you can if there are other circumstances, like if there's excessive force. Yeah, if the cops beat somebody up after they arrest them, then there may be a Bane Act violation there, but it is not arising out of the unlawful arrest. The unlawful arrest by itself would not precipitate a Bane Act violation. And before people get all upset with me that I didn't go into all the possibilities about what could, I was responding again to a very specific situation. There was no threat of imminent force being applied to SGV News. There was only the threat in his mind of an unlawful arrest, which the Bane Act would not support an action on, just an unlawful arrest. So Eric realized that I was in fact right, but he wants me to go into the other things, and it's not pertinent to anything. It's just not relevant, and that's why I say and do the things I do, because I'm responding to specific questions. There are a billion hypotheticals out there. There are more hypothetical situations than there are people in the world where you can get into some, well, it's a margin call kind of situation. Most of these things are margin call. Is there news? Well, is what SGV filming news? 90 some odd % chance that it's not news. But there is a chance, a slim chance, that a court would find that what he's doing is actually gathering news. But it's a slim chance. And you can get into those areas. My goal is now, and always has been, though, to give clear, legal interpretations that will keep people out of trouble and hopefully prevent people from saying and doing stupid things, like threatening cops with Bane Act violations when there is no Bane Act violation to be found. I don't like to get into nuance with people who don't understand nuance and who lose context, because there's a lot of people who lose context. I was asked a very specific question about why 5 out of 4 Supreme Court justices can determine what the law is, but it takes a full jury panel, the whole 12 jurors, to determine guilt. All 12 jurors have to say that the person is guilty in order for them to be found guilty of the crime. Why is that? Well, the simple, easy explanation that is accurate is that judges determine the law and juries determine guilt. We want more protections for determinations of guilt, because when it is applied then and there, somebody's going to face punishment, fines for it. With a determination of the law, it is not as imminent. People can react to it. People can become aware of the change in the law. It's built in. They can modify their behavior accordingly. And it's controversial. If it wasn't controversial, it wouldn't have gotten up to the Supreme Court. Non-controversial things don't make it out of the lower courts. If it's slightly controversial, it might get to like a state appellate court. Or if somebody has money, very, very low controversial things or non-controversial things may actually make it up and get a decision on it. But generally speaking, the more controversial it is, the more likely it is to move up the ladder of review. The Supreme Court has discretion on whether or not it hears a case. And so it literally picks cases where it feels that there is clarification needed, where there's enough controversy that the Supreme Court has to step in. And so there is always going to be, there generally are going to be split decisions on that. Most decisions are going to have one or more dissenters, because they are complicated issues, and reasonable minds can reasonably differ about what way a law should be interpreted. But whether or not someone's guilty, that's supposed to be beyond a reasonable doubt. It's a different standard. It's a different thing. Someone's life may be on the line, and that's the difference. Well, I had some retard jump in and say, well, judges don't always determine the law, and juries don't always determine guilt. Sometimes the judge determines guilt. Well, that's not a review-based thing. That's not a nine-panel Supreme Court doing that review. That's at the trial level. That's not responsive to the pending question about why it takes only 5 out of 9 justices to determine what the law is, but it takes 12 out of 12 jurors. It's not responsive to that. It's out of context. If you want to talk to me about why a single judge can make a determination of guilt, we can talk about that, sure. But that's not responsive to, I think it was Seb's question. Anyway, I hope that clears it up. When I say the things I say, I am responding typically to specific questions. I'm not wrong. You guys have a hell of an issue finding me wrong. Not to say that I've never been wrong, obviously. I've mea culpa'd more than once. But this is not a mea culpa because I was not wrong. And thank you, Eric, for having the graciousness to point out that I wasn't wrong. Thanks for watching. Have a great day.